The clerk will read the order of the day.
Government Business Notice Number 3, standing in the name of Mrs Hersey to present the Education Legislation Amendment Bill 2025, Serial 14.
Minister.
Madam Speaker, I present a bill titled Education Legislation Amendment Bill 2025, Serial 14, and table the explanatory statement. Madam Speaker, I move the bill be read a first time.
Please continue.
Madam Speaker, today I present a bill entitled the Education Legislation Amendment Bill 2025. In August last year, the CLP government was elected with a strong mandate from Territorians to reduce crime, including to address the root causes of crime. One of these root causes is a failure to ensure our young Territorians receive a quality education. The purpose of this bill is to amend the Education Act 2015 and Education Regulations 2015 to introduce measures that will strengthen school attendance. This reforms will achieve this by enshrining the role of school attendance officer in the legislation, streaming and improving existing enforcement processes, and prescribing the identity management information required to be collected by schools in order to support the national rollout of the Schools Identifier in 2027. Madam Speaker, school attendance is mandatory for all children between the ages of 6 and 17 in the Northern Territory. There are existing compliance measures in the Act already. These measures are aimed at enforcing the obligations that parents have to send their kids to school. However, the last 8 years has seen a steady decline in attendance at Northern Territory government schools across all regions of the Territory. For example, from 2016 up until 2023, Barkly dropped from 62.8% to 46.2%. Big Rivers from 71.1% to 58.9%. Central from 75.9% to 66.3%. East Arnhem from 59.9% to 54.6%. And Top End from 83.6% to 78.3%. Darwin from 88.8% to 83.8%. So, Madam Speaker, the August 2023 age grade census told us there were 32,652 students enrolled in government schools, with the average annual attendance at 74.5%, a drop from 80.8% in 2016. The 2023 data showed that the Territory's attendance rate of 74.5% was the lowest in Australia and significantly lower than the national average of 87.5%. This decline has coincided with a reduction in applying the compliance measures that are already available under the Act. For example, in 2016, a total of 1,580 compliance notices were issued, compared to only 454 in 2023, a reduction of 73.4%. Madam Speaker, further to this, only 38 infringement notices were issued in 2023, compared to 365 in 2016, a reduction of almost 90%. Staying in school is closely associated with reducing crime rates through several interrelated mechanisms, such as increased employment opportunities, development of social skills and networks, improved critical thinking and decision-making, access to resources, and learning in an environment that fosters a sense of purpose and direction. Madam Speaker, these compliance measures exist in the Act for a reason, and that is to enforce the law by ensuring that parents are aware of their obligations to send their kids to school and understand that there are consequences if they do not. This reform does not implement new provisions that enforce a parent's obligation to send their kids to school. These powers are already available to department officers who are appointed as authorised persons by the CEO of the Department of Education and Training. The issue is that the powers were underutilised due to the many classes of department officer appointed as authorised persons, with none of them having a focus on compliance and enforcement. For example, student engagement advisors, school-based engagement officers, court officers and staff employed in corporate positions within the department are all appointed as authorised persons under the Act. While all of these positions have the power to undertake enforcement action as authorised persons, enforcement is not a core function of these roles. Under this structure, student engagement advisors were primarily responsible for issuing enforcement notices and infringement notices. However, this role also performs the important function of providing supportive case management to chronically disengaged students and providing support to families and young people to overcome the barriers that perpetuate non-attendance. In this role, the combination of therapeutic case management and enforcement functions created a conflict, and enforcement measures were only relied upon as a measure of last resort. In fact, the Northern Territory Government delivered on its election commitment to bring back truancy officers in Term 4 2024 by establishing school attendance officers as authorised persons under the Act. School attendance officers commenced their patrols in Term 4 last year, and up until 13th of December 2024, issued 476 compliant notices and 38 infringement notices. In one term, our newly established school attendance officers issued more compliance notices than were issued in a year in 2023 and equalled the number of infringement notices issued. What these reforms will do is enshrine the role of the school attendance officer into legislation so that a dedicated position with a focus on enforcement will continue to exist as part of government's overall attendance and engagement strategy. The school attendance officer will be a key component of a broader strategy for increasing and maintaining school attendance rates. The ability for the CEO to appoint authorised officers under the Act is maintained, reinforcing that a multifaceted system of support, factoring in a range of roles, methods and tools is required to address disengagement, truancy and absenteeism. Madam Speaker, this reform creates a balanced approach to increasing and maintaining high attendance rates by separating out supportive and enforcement functions, enabling an increased focus on enforcement to occur without neglecting the requirement to provide intensive case management and support. More specifically, Madam Speaker, these amendments create a new section in the Act that prescribes the functions and powers of the school attendance officer by combining the powers of the CEO that are associated with enforcement actions under sections 171 to 173, with the powers of an authorised person to manage truancy under sections 174 to 176 and Regulation 44. Put simply, school attendance officers will have the power to request information by issuing an information notice, issue a compliance notice, direct a person to attend a compulsory conference, approach a school-age person in a public place and ask questions, for example, name, address, why they aren't in school, and accompany the child back to their school or to their home. Call at an address given to them and require any person over 14 to give information about school-aged children who reside at the address, direct the enrolment of a child in a school, issue infringement notices, monitor and enforce compliance with the provisions of the Act relating to school attendance, and conduct education awareness programs and provide information and advice about school attendance. Madam Speaker, this bill also addresses an existing issue that hinders the efficient giving of notices associated with monitoring and enforcing school attendance. Currently, under Section 168(4) of the Act, an authorised person must present their identity card for inspection to the person when exercising any power in relation to that person under the Act. The Department has legal advice that this provision may imply that an authorised person may only exercise a power in relation to a person when the person is physically present. The giving of notices by an authorised person, including a school attendance officer, via any other means than in person may be invalidated by a court if challenged. The amendment rectifies this anomaly. Madam Speaker, the amendment clarifies that an authorised person is only required to produce their identity card for inspection to a person when exercising a power or performing a function under the Act in the physical presence of that person. This reform is aimed at making the issuing of notices more efficient in situations where the parent or young person is unable to be located, or where it is unsafe to approach a parent or young person, or where it would otherwise be more efficient to issue an infringement or other notice via email. This amendment does not remove the requirement for an authorised person to be issued an identity card in order to exercise a power under the Act. Finally, Madam Speaker, this reform will see the Northern Territory satisfy its national commitment under the Better and Fairer Schools Agreement to ensure the Territory is ready to support the rollout of the National Schools Identifier in 2027. In November 24, the Better and Fairer Schools Information Management Act 2024 passed through the Australian Parliament. The purpose of the Act is to amend the Student Identifiers Act 2014 in the Commonwealth to extend the system of unique identifiers that currently exists for vocational education and training and higher education students to school students. The Unique Schools Identifier, when implemented, will enable the tracking of students across jurisdictions and provide a safeguard for students at risk of disengagement from education. Madam Speaker, the Commonwealth legislation includes provisions that define the identity management information that schools must collect in order to inform the generation of schools identifiers. The Commonwealth legislation also includes provisions that support the sharing of sensitive data across borders for the purpose of applying for or verifying a school's identifier. Under the school's identifier operating model, all primary and secondary school students who do not already have a unique identifier will receive a school's identifier. The school's identifier will be generated using data collected at the time of school enrolment. For students who already have a unique identifier, enrolment data will be used to locate their existing unique identifier. Madam Speaker, from 2027, both government and non-government schools across Australia will be responsible for collecting the information required to inform schools' identifiers. To ensure Territory schools are collecting the data required, an amendment is proposed to update the regulations which already prescribe data that is required for enrolment purposes for both government and non-government schools. As the school's identifier is not due to commence until 2027, the bill proposes a delayed commencement for these provisions. The delayed commencement will enable both the Northern Territory and Australian governments to work with government and non-government school sectors respectively to ensure systems and processes to support the collection of the required additional data are established. Madam Speaker, once the National School Identifier is established, we will be able to track and support students at risk of disengagement from education. For example, students who unenrol from a school but fail to re-enrol in another, including across borders. This is particularly relevant for the Territory considering the number of students from remote communities who attend interstate boarding schools. The school's identifier may also assist with gaining a better understanding of student pathways, enabling the targeting of additional supports and programs where required to better support young people at risk of disengaging from education. Madam Speaker, as I've mentioned, staying in school and receiving a quality education is closely associated with reducing crime, and the proposed reforms constitute a clear measure by the Northern Territory Government to encourage regular attendance in compulsory education and reduce disengagement. And Madam Speaker, for the last 4 years in opposition, I've spoken about the importance of education. We have the lowest rates of literacy, numeracy and attendance, and we must get our kids to school for a better future for them and for a better future so we've got more people accessing jobs in the future. We need parents to understand the importance of education. I've been out with numerous school attendance officers right across the Territory and seen the great work that they have been doing out on the ground. And I can tell you, Madam Speaker, the word is definitely getting out there to families. Families are now understanding the importance of their child's education better. They are understanding that, it is the law to send your child to school, and there will be accountability and a consequence for them in the way of a fine if they do not. So I'd just like to thank the department and to all the school engagement officers right across the Territory who are doing a fantastic job, Madam Speaker, and for the hard work that they're doing. So I'm pleased to commend this bill, the Education Legislation Amendment Bill 2025, to honourable members and table a copy of the explanatory statement. Thank you.
The question is that the bill be read a first time. Those of that opinion say aye, to the contrary, no. Aye. I think the ayes have it. The clerk.
A bill for an act to amend the Education Act 2015 and the Education Regulations 2015.
Minister.
Madam Speaker, I move that the second reading of the bill be made an order of the day for the first Assembly meeting after 28 days have elapsed.